Good evening and welcome to the fourth installment, our last installment, on the law of restoration. I am Gobonde Wasebe Haji, Minister of Foreign Affairs for Lodium Moorish Pradium ante Colorado. And today we're going to continue with our lesson. We're going to start with the preamble. And so, would you read the preamble, Maya?
We the Moors in Morocco, the mothers and sons of northwestern Exum, northwest Alkebulan, the North Gate, and standing on our 5 points of light, love, truth, peace, freedom, and justice, in order to restore a balanced order, just protections, reciprocal wealth, and cultural integrity for ourselves and our just sanguine heirs, do establish this law of restoration for the organic state, Allodium Moorish Pradium ante Colorado.
Okay, now our preamble says it all. It doesn't say how we're going to get it all done, but it says it all. And so the rest of the Constitution informs us on how we're going to move and how we're going to function, how we're going to cooperate together, how we're going to hold each other accountable, and what actions we're going to take domestically, internationally, and so forth. Okay, so what we're going to pick up with is where we left off. We finished with Article 4, which was the National Trust. And we're going to pick up today with Article 5, General Provisions. And then after we go through everything, we're going to recap and just do a brief summary and go through everything so that we can get a really good understanding of the whole picture, because our Constitution is the key element of statehood. Without a Constitution, there is no state. And if there is a state claiming to be a state and it does not have a Constitution and it has not initiated proceedings to develop a Constitution, then its statehood is basically on hold for all intents and purposes. So, general provisions. This government shall be fully representative. No one serving in an office shall receive a salary, compensation, or other financial gift structure. Every official is entitled to receive, within reasonable limits, with documentation, reimbursement for expenses incurred while carrying out government affairs. Each official is also a matrilineal national and will receive the same benefit from national distributions that all other matrilineal nationals receive. Now, this clause is quite different from what you see in most other constitutions. Government offices are not paid positions. Career politicians have proved to be ineffective and self-serving and deleterious to the well-being of the people. So to eliminate that, everyone is on a level playing field, and who's serving in office are the ones that want to serve in office. As the government grows, as AMPAC expands, as our mandate is more fully expressed, the revenues that come in as a result from consumption taxes, rents, transfer taxes, levies and fees, and all the things that we are authorized to assess by law, by treaty, and so forth, those revenues will be divided up, as we had described earlier, in the National Trust section. And each official, being a national, would benefit from that. So no one would be left out. Okay? Number 2, every elected or appointed official works for the people who are the nation. Any attempt to confer upon oneself a title other than the title they are elected to is prohibited and will subject the official to investigation for infractions against the people, their office, and the national government. Now, this is here to protect us from those who would engage in self-assignment or self-appointment. And self-assignment is frowned upon in the international community, because what it means is that there's been no election, there are no terms of office, there's no checks and balances, and basically a person has put themselves into a monarchical situation for their own ends, for their own means, for their own emolument. So this is a clause that we have in our general provisions to protect the state from those that might be in office who want to assume a greater position without having been elected, you see. So the Constitution serves to inform the people and to help to regulate, but also to protect the people and protect the state from those that have nefarious means and ends. Number 3, there shall be 2 status within Allodium Moorish Preamble, Colorado. Those 2 status are matrilineal national and patrilineal national. Now, matrilineal, we know, deals with the mother. Patrilineal deals with the father. The reason we have these 2 statuses is because of the texture and context and fabric of the larger community and what has taken place over the last 300 or 400 years. The conquering that took place in relationship to our peoples was done through out-and-out murder, was done through miscegenation, rape and pillaging, was done through mis and reclassification of the peoples, was done through managing and theft of resources and lands and so forth and so on. So understanding these 2 statuses helps to bring things back into balance for the Moorish bloodline. So the matrilineal national is, of course, based on the mother's lineage. The mother, the grandmother, the great-grandmother, the great-great-grandmother, and the great-great-great-grandmother, so on and so forth, ad infinitum. And the patrilineal national claims their status as a Moor through their father. Okay, and it doesn't go any farther back than that. Through their father. If the father is a Moor, then that child is a patrilineal national in AMPAC. Okay? So let's just define these and take a closer look. A matrilineal national, one who is by birthright of their Moorish mother, one who has declared and proclaimed their nationality standing as a Moorish matrilineal national, also one who has made a specific pledge via oath and allegiance to this provincial government within the dominions of the greater Moroccan Empire, thus denouncing any prior allegiance and oath to a foreign power. So, matrilineal national. Now, we've recently made a change in that to clarify the issue so that we're staying in alignment with international conventions, international norms. Okay? Then there's patrilineal national. Chad, would you read that?
One who is by the DNA of the Moorish father claiming a Moorish standing. Also one who has made a specific pledge as a patrilineal national under an oath and allegiance to this provisional government within the dominions of the greater Moroccan Empire. Patrilineal national status prohibits one from holding a national office, receiving full allotment from the national trust, and holding allodial titles to aboriginal land. Also, they are denouncing any prior allegiance to a foreign power.
Okay. Now, the patrilineal national is a status that has sort of a diminished status. But they're still Moorish nationals within AMPAC. They're AMPAC Moors, still the same. They receive the same protections, have all the same rights. The reason that certain things are in place is because of the position in relationship to descendancy of their estate. Okay? The patrilineal national, it says, prohibits one from holding a national office. Now, they can be appointed to a deputy position, a vice position, a sub position that's not necessarily a primary national office, but not elected to a national office. The full allotment, they would receive a reduced amount when there are distributions made from the national trust. The reason for that is that due to the status, having the father as the sole heir puts them in a position that if anything were to happen, it would descend to the state. it would not descend to the mother if the mother is not a Moor. You see, so it puts things in perspective, so you can understand that the incentive is to bring children into the world in Moor status as matrilineal nationals. So if you're bringing children into the world and they're patrilineal nationals, and you know that, you're putting them into a lower status. You see, so that's what's happening here. So we're giving an incentive to help to reclaim the bloodline, to reclaim the pedigree, to rebuild the Moorish nation, the Moorish state, and the Moorish bloodline. Now, in terms of holding title to Aboriginal land, that's because the descendancy would be to the father, and descendancy in AMPAC is through the mother. So it precludes them doing that anyway. Okay? So let's go on. Number 4. In every society, there are crimes which affect the well-being of the people in adverse ways. 5 crimes shall herein be addressed as anathema to the civil function and free expression in our nation. These 5 crimes are: theft of personal or national property. 2, damaging personal or national property. 3, causing physical harm to any woman, man, or child. 4, causing the death via murder of any woman, man, or child. 5, treason against the nation and the nationals. Now, these are basic crimes within every society. Now, of course, you can extrapolate and say, well, what about this and what about that? And there's all kinds of gradations of it, but they all fit within those categories. Ma, would you read the next one?
All the crimes listed must have an injured party, victim, and/or personal witness to the fact, which can be attested to by oath and affirmation. The Qazi shall oversee the adjudication of the case regarding the crimes committed. The sentence required by the Qazi shall be unique to each situation for the first 3 crimes. Thereafter, the crimes of murder and treason have specific penalty and punishments mandated.
Okay, thank you. So these first 3 crimes that deal with theft, damage and harm to a person, and what was the other one? Causing physical harm, damage, and theft. Okay. So what's happening here is there must be an injured party. There must be a witness. That witness can be the victim, which can be attested to by oath and affirmation. So if the person that is injured does not make an oath or affirmation claim that they've been injured, there is nothing to investigate, because they're saying that no crime was committed, and they're the primary witness, you see. Now, when we get to further, the sutra shall oversee the required investigation into each of these crimes, along with the sharif. Their investigative protocol shall be in respect of all the matrilineal nationals or patrilineal nationals' unalienable rights. Their findings shall be presented to the Qazi for preparing the necessary court proceedings. So the Sutra, who is the Secretary of Defense, and the Sharif are charged with investigating a crime that has been put on the record, attested to through oath and affirmation, which means an affidavit has been done, the witnesses have been found, and so they go through the process of investigation to find out what actually took place. And then that information goes to the Qazi with a recommendation of charges, and the Qazi then would subpoena the parties, and the parties, it would be adjudicated as to what took place, and a judgment would be made as to what needed to happen to bring parity or to bring equanimity back, you see, or restitution, whatever was required. Now, the first 3 crimes of theft, property damage, and physical harm must have an injured party, affidavit of fact attesting to the crime by the victim, evidence corroborating the affidavit of fact, and at least one witness. The fourth crime of murder must have evidence showing proof of deceased person, evidence showing cause of death, and witnesses corroborating the evidence beyond a shadow of doubt. Capital punishment shall be administered with cause by this provincial government. So we are not adverse to capital punishment. And we spent many hours discussing this, back and forth, forth and back, round and round, up and down. The punishment for the crime of murder shall be in two categories. First, the murder was committed by a matrilineal national or patrilineal national upon a citizen of a foreign country, foreign nation. In this instance, after complete investigation and adjudication, the matrilineal national or patrilineal national is found guilty of murder, they shall be turned over to the offended nation's officials for further sentencing and punishment. Thus, there shall be complete and irrevocable expulsion from the nation for the offending matrilineal national or patrilineal national, and destruction of any evidence of national allegiance on file with the provincial government. They are turned over to the offended nation's officials with a proviso to follow international law and treaties in their adjudication and sentencing. Notification of this punishment shall follow them throughout the Moroccan Empire. Second, the murder was committed by a matrilineal national or patrilineal national against a matrilineal national or patrilineal national. In this second instance, there shall be a complete investigation if the matrilineal national or patrilineal national is found guilty of murder. After complete investigation, adjudication, and sentencing, the punishment of death shall be carried out immediately. Okay? They have not only broken the national trust, they've broken every form of law that you can imagine. It's an unconscionable crime to commit murder. Okay? So the fifth crime is treason against the nation and the Moorish nationals, which carries a penalty of capital punishment. To be found guilty of treason, 2 witnesses to the overt act against the nation shall be sufficient to initiate a full investigation into the treason. The 2 witnesses must each provide an affidavit of fact detailing in explicit fashion the entire scope of what was witnessed, including all parties involved. After complete investigation, adjudication, and sentencing, the punishment shall be carried out immediately. Okay? Now, under these instances, the capital punishment may not be the death penalty. It may be expulsion, exile, or something else. Number 5. Chad.
Whenever conduct of an official is in question, whether for an official position or for disciplinary action, the parameters used for making such assessment and evaluation as to their capacity for behavior compliance, conformity, and allegiance to the law of restoration, Constitution, the Dali Aziz shall be guided by the 5 points of light of love, truth, peace, freedom, and justice. The 7 Hermetic principles being mentalism, correspondence, vibration, polarity, rhythm, cause and effect, and gender. The 7 virtues of Ma'at being truth, justice, propriety, harmony, balance, reciprocity, and order. The 10 principles of Ma'at to have 1. Control of thought, control of action, devotion to one's purpose, faith in the master's ability to teach the truth, faith in one's ability to assimilate persecution, freedom from resentment under wrong, ability to distinguish right from wrong, and the ability to distinguish the real from unreal, and the 42 Declarations of Innocence as follows.
Okay, stop right there. Now, all of these that we've represented are all the fundamental principles that the Dalil Aziz uses to evaluate and assess an official or a national, depending on the situation, as to any disciplinary action, anything that has to relate to their behavior between nationals and so forth, their behavior in relationship to the nation, how they're expressing and representing the nation, the state. So all of these principles are taken into account. And if not every single one, a compendium or a small group or just whatever is applicable at the moment regarding the situation. So this last grouping, the 42 Declarations of Innocence, as follows. Now they're listed here, all 42. And I'm going to go through them. I'm not going to talk about each one. It would take too long. But it says, I have done no wrong. 2, I have not robbed. 3, I have not acted with violence. 4, I have not killed. 5, I have not been unjust. 6, I have not caused pain. 7, I have not desecrated holy places. 8, I have not lied. 9, I have not wasted food. 10, I have not spoken evil. 11, I have not committed sodomy. 12, I have not caused the shedding of tears. 13, I have not sown seeds of regret. 14, I have not been an aggressor. 15, I have not acted guilefully. 16, I have not laid waste the plowed land. 17, I have not entered into conspiracy. 18, I did not bear false witness. 19, I have not been wrathful. 20, I have not committed adultery. 21, I have not committed adultery. Now there's a specific reason that it's in there twice, and we'll get into that another day. 22, I have not polluted myself. I have not caused terror. I have not polluted the earth. I have not spoken in anger. I have not turned from words of right and truth. 27, I have not uttered curses. 28, I have not initiated a quarrel. 29, I have not been excitable or contentious. 30, I have not prejudiced. 31, I have not been an eavesdropper. 32, I have not spoken overmuch. 33, I have not committed treason against my ancestors. 34, I have not wasted water. 35, I have not done evil. 36, I have not been arrogant. 37, I have not blasphemed the one most high. 38, I have not committed fraud. 39, I have not defrauded temple offerings. 40, I have not plundered the dead. 41, I have not mistreated children. 42, I have not mistreated animals. Now, all of these principles, it's a lot. They are thousands of years old. These are not new inventions. These are ancient principles that we're bringing forward into our law of restoration. By doing that, what we're doing is we're making the law of restoration a compendium of and a representation of the highest and best of jurisprudence, the highest and best of culture, the highest and best of civilization. Okay? The 5 points of light, 7 hermetic principles, the 7 virtues of Ma'at, 10 principles of Ma'at, and the 42 declarations of innocence stand as the foundation for our societal, cultural, and spiritual development. Okay? Let's go on into Article 6. The Supremacy Clause. Now this is key, because what we're doing here is we're actually laying down what the supreme law of the land is and what the state's delegation of authority is to actually exist. So, Ma'at.
The supreme law of the land is this law of restoration as well as all treaties made or which shall be made under our national seal and flag. Our delegation of authority for establishing this law of restoration are the great law.
Okay, stop right there. Okay, that first sentence, the supreme law of the land is the law of restoration, as well as all treaties made or which shall be made under our national seal and flag. So this document, the Constitution, is the supreme law of the land. There's no higher law. What we have done, we have added to it. Not in the Constitution, but we've added to our lexicon of law through acceding to treaties, through acceding to the United Nations Declaration, or United Nations Charter rather, United Nations Universal Declaration of Human Rights, and then many, many others, at least 36 or 40 declarations, conventions, covenants, and so forth that we have acceded to. And when we accede to them, we actually step in, we ratify it within our legislature, which is the Dalil Aziz, and we send that to the depository of the United Nations, which is the Secretary General's office. They have a treaty office, Office of Legal Affairs, that receive all treaties and they deposit them. If it's a multilateral treaty, then all other parties to that treaty are notified that there's a new member of this treaty agreement. There's a new party, you see. So that's what we've done. So we are in international communication. Okay, international law is the law that we operate upon. Okay, now go back to that second sentence and start over.
Our delegation of authority for establishing this law of restoration are the great law of peace from what is today known as the Iroquois Confederation, the Treaty of Peace and Friendship between the United States of America and the Sultan of Morocco, 1786, 87, and 1836. The J Treaty, the Treaty of Amity, Commerce, and Navigation between Great Britain and the United States of America, 1794. The Treaty of Peace and Friendship between the United States and the Bey and subjects of Tripoli of Barbary, 1797. General Treaty between the Great Britain and Morocco, the Empire, signed in English and Arabic languages at Tangier, December 9, 1856. Right of Protection in Morocco, July 3, 1880. General Act of the International Conference of Algeciras, April 7, 1906. Charter of the United Nations, 1945. Vienna Convention on Diplomatic Relations, 1961. Vienna Convention on Consular Relations, 1963. Vienna Convention on the Law of Treaties, May 23, 1969. April 24, 1970, and entered into force on January 27, 1980. And for general reference and support, the Universal Declaration of Human Rights, United Nations Declaration of the Rights of the Child, United Nations Declaration on the Rights of Indigenous Peoples, the Law of Nations Universal Just Sanguine Claim of Self-Determination, and the allodial right to establish our own cultural, social, economic, political, and civilized society on our own land.
Okay, that is our delegation of authority. So when someone says, well, what gives you the right? Well, we've acceded to all of these treaties. We've acceded to all of these conventions and declarations. That's part of our law. This is what gives us the right to exist and function as a state. Now, ultimately, it's the people that gave us the right through the election. And we evidenced that election through our inauguration. But the delegation of authority to initiate all of this is right here. It's irrefutable. It's undeniable. And understanding this, the rights that the state is afforded, that a Moorish state is afforded in northwestern Mexico, is vast and comprehensive. We have original jurisdiction in Morocco. We have extraterritorial jurisdiction in Morocco. The United States, up until recently, had a limited consular jurisdiction only because Moors had acquiesced and gone silent for so many years. So the United States stepped in and acclaimed a limited privilege of consular court. We see it manifested in traffic court, family court, other types of venues. But it's what they're doing. Okay. The provincial government and all Moorish nationals therein shall stand upon the 5 points of light, love, truth, peace, freedom, and justice. We, the autochthonous, aboriginal, and indigenous people within our dominions here in the Empire of Morocco, northwest of Mexam, northwest Al-Kabalon, and the North Gate, shall remain true to the ideals of law and jurisprudence herein reflected. So this is the Supremacy Clause. Now, our amendment protocol, very simple. Article 7. Chad.
The power to amend this law of restoration is in the hands of the Daliazi. A vote of 85% by the Daliazi and the Matrilineal nationals voting, respectively, is required in order to approve any bill which would amend this law of restoration. Each and every matrilineal national must be given the opportunity to cast a vote either yea or nay regarding the amending bill in question.
Okay. So that's our amendment protocol. It's very simple, it's direct. The Matrilineal Council, the Dalil Aziz, is the determining factor in relationship to constitutional amendment. Now, that ends our law of restoration, and you can see the names represented as to when, and we have certain amendments that have been made, the dates and so forth. Now, I'm going to go back up to the beginning. We're not going to read the whole thing, but we're just going to go through it again. If you look on the board here, Preamble. The Preamble is our initial statement, our statement of being, our statement of purpose, our statement of mission, our motivation. The dominion spells out our land, our permanent territory, the territory that we claim that is ours by Aboriginal indigenous right, that we are claiming under international law. And when the state is established, there is a legal maxim or phrase that's used. It's called uti possidetis juris. Uti possidetis juris. Let me see if I can spell that. Uti possidetis juris. And what that says is when a state is established as a return within an occupied territory, and this land is occupied by under a corporate jurisdiction, feigning to be a government. When we do this, and in our return, the boundaries of our territory become international boundaries. So our dominions are internationally designated through this principle of uti possidetis juris. Our rights. We laid out our rights within the unalienable rights section of our Constitution. Now, those rights are not all the rights that exist, and the state is not giving the rights. The state is acknowledging the rights that already exist for all AMPAC Moors. Okay? 3 branches of government. That's the Divan. 3 branches of government. You have your executive, your legislative, and your judicial. Our executive branch is headed by the Wazir al-Reis. The legislative branch is called the Dalil Aziz. It is headed by the Sayyid Raha. The judicial branch is called the Darul Abdul, and its officers are the head Qazi and other Qazi under them. So that's the 3 branches. And then the National Trust. The National Trust is an essential element that we've included into our government structure so that we can interface with the international community in terms of economics, assets, lands, business, trade, and commerce, and so that we can provide additional protections for our nationals in both jurisdictions. General provisions. We went through the general provisions. General provisions usually is provisions that are not specific to a particular section that we've gone through, but they amplify and expand upon the principles of governance and what's needed in order to carry out our mandate as a state. And then the Supremacy Clause and delegation of authority. The Supremacy Clause being the Constitution and all treaties made or which shall be made. And then the Amendment Clause or Amendment Protocol. How is this Constitution amended? How can it be changed? How can it be updated? And we have a protocol for that. So when if you're working on a Constitution, just check the boxes and make sure that you're covering all the bases. Don't leave anything out. Don't be too detailed, but you want enough so that you can begin to fill it in through legislation, through protocols, through policies, and through other law, and with accessions to international treaties, international declarations, and conventions and covenants. Okay? So, that's enough for the AMPAC Constitution. There's a couple other things I want to go through that talk about Constitution in general. So let's go to another document I have here. It's called The Law of Nations by Vattel, V-A-T-T-E-L. It was actually written in about 1760. And the second edition was being worked on, and the gentleman Vattel died in 1767. So that part didn't get finished, but his notes were taken and it was expanded on, and there is a version, I think this is it, that improves on and adds what he was working on. Now, the reason we use this is because it is, sometimes the older documents are less tainted with modern biases. That's a good way of putting it. Yeah. So it gives a more true sense of what the state is, what a government is, what international relations are, in a pure sense, without having to deal with all of the preconceived political wrangling that's taken place to adjust and maneuver and manipulate those concepts. And of course, there are certain concepts that are not represented, but the basic principles are here. Now, this section I'm dealing with is on treaties, not on the constitutions. And it says, the Constitution and laws of a state are the basis of the public tranquility, the firmest support of political authority, and a security for the liberty of the citizens. Now, in 1760, citizens was a progressive term, because prior to 1760, in the 1700s, there were not a lot of countries or nations that had citizens. They had subjects, because they were dealing with monarchical structures, you see? So the concept of a citizen was also related to a republic. The concept of a constitution was related to a republic where the people had the right, their voice had a right to determine who their rulers and how their government was going to be operated. So at the time, this was very progressive writing, but it still has some bearing on us today. So the Constitution and the laws of the state are the basis of the public tranquility. If the Constitution is bad, there'll be no tranquility, because there'll be confusion, there'll be chaos. People won't know what's right and what's wrong in relationship to the state. People will be taking the Constitution and convoluting it towards their own personal interests. And I like to think that we put together a Constitution that eliminates a lot of that personal aggrandizement. It says, but this Constitution is a vain phantom, and the best laws are useless if they be not religiously observed. The nation ought then to watch very attentively in order to render them equally respected by those who govern and by the people destined to obey. So the laws of the state must apply to everyone in the state. They must apply to those who are officials, who are given a mandate to exercise the law and enforce the law. And it also has to be by the people who have given those officials those positions. The law applies equally to everyone. To attack the Constitution of the state and to violate its laws is a capital crime against society. Now, this is interesting because we see this happening all the time. In the world, you can see it. Within countries, you see their constitutions violated. It's countries that have acceded to certain international conventions and declarations of peace, Universal Declaration of Human Rights. You see human rights violations happening all the time. Why do they happen? Because people attack their own constitution and thus attack their own people and violate its laws. And that becomes a capital crime against society, against the people. So people talk about governments as though governments are bad. It's not that governments are bad. The people administering the government are out of order, have not been given the proper guidance, and have not been checked. If those guilty of it are invested with authority, they add to this crime a perfidious abuse of power with which they are entrusted. So abuse of power. In our three branches, we have a paragraph in each of those that talks about this. The officers in this branch are constrained from influence peddling, constrained from receiving bribes, constrained from receiving emoluments from a foreign power, constrained from creating offices without having prior approval. So then there's a number of them, you see. All of this is to protect us from this, which when they had constitutions, they may not have had clauses in there to protect them from that. So they were at the whim of whoever was understanding the law, and there were loopholes, and some constitutions were like Swiss cheese. You could just run in and around them and do whatever you wanted to do, as long as you jumped back in at the right time and claimed a certain immunity. Literally, that's how it was. The nation ought constantly to repress them with its utmost vigor and vigilance, as the importance of the case requires. Now, this is interesting because we're not talking about the state repressing anyone, but the state does have to protect itself. Now, what we've learned is that the state can protect itself with the pen by creating legislation that protects the state, creating legislation that gives clear guidelines to the officials on what they can and cannot do, and then making sure that the people understand what those are so the people can hold those officials accountable and have a process through which to hold them accountable. So for instance, in AMPAC, if a Moor in AMPAC sees an official doing something that is against the laws of AMPAC, that official can be reported, and that national can report it to the Sharif, the Consul General, the Sayaraha, report it to any other official, and it will get taken care of. If it doesn't, then that official that did not do anything becomes culpable, becomes a co-conspirator in that infraction. And then it needs to be taken to another place. Now, Moors need to know this. See, we like to think that everything that happens happens because of the other. And we have to realize that we have to know how to take care of ourselves and police ourselves and monitor ourselves so that we keep ourselves in check, so that we uphold the constitutions that we honor and that we live by so closely and so dearly, and will provide protections for us. It is very uncommon to see the laws and constitution of a state openly and boldly opposed. It is against silent and gradual attacks that a nation ought to particularly be particularly on its guard. Now, every constitution, what they said, you'll very seldom see a blatant out and out attack on the whole constitution. But what you'll find is that there'll be a little bit of nitpicking here. Let's pull this out here. Let's do this here. Let's change this here. So they start to pull threads at the Constitution, so to unravel it, so that it gives those parties more leeway in committing crimes with impunity. That's what we must guard against. But we overlook the changes that insensibility happen by a long train of steps that are but slightly marked. Now that's sort of an obfuscated sentence. But basically what it's saying is that throughout history, you can see the minor little changes that take place in history that eventually unravel a state. You see, a state will unravel if it is not on guard and protects its foundational documents, its foundational principles. It would be rendering nations an important service to show from history how many states have thus entirely changed their nature and lost their original constitution. This would awaken the attention of mankind, impressed thenceforth with this excellent maxim: no less in politics than in morals. So you see, morals and politics are not higher than each other. If a person's morals are low, their politics will be low. If a person's morals are high, their politics will be high. That's how it works. They would no longer shut their eyes against innovations, which, though inconsiderable in themselves, may serve as steps to mount a higher and more pernicious enterprise. So little steps, little things done to undermine the foundational principles of the Constitution have to be guarded against. So those who are administering the Constitution must constantly be on the vigilance against those that would come and try to undermine its foundation by saying, oh, well, this isn't valid. We got to change this because that's not valid. Oh, we're not this, so we're going to change this. And next thing you know, it becomes an empty shell with no force, no power, no imperial edict. Imperial mean not imperial like, imperial empire, but imperial or imperium meaning the ability to command, to enforce, to express. Okay? So this is a section I wanted to share to give you an idea of what to watch for when we're dealing with our Constitution. Our Constitution, if it's used properly, can be a very powerful tool. A very powerful tool for saving us and our people. Okay. Let's go on. I wanted to share this as well. I think in a past, when we were talking about the three branches of government, we talked about the oath taking, we talked about our inauguration, and we talked about our tome, T-O-M-E. And our tome is about 8 inches thick, red cover top and bottom, 8.5 by 11. And it's made up of a number of documents. And I'm going to read off some of these documents so that you can see them and appreciate what we did. This is the table of contents for our tome. The first one we had at the very top of it was the law of restoration. So when the inauguration was done and you put your left hand on the tome, you were placing it on the law of restoration. That was the first document. Okay. The second document was the Great Law of Peace by the Haudenosaunee Confederation, also known as the Iroquois, dated from around 1100 AD. And then we had the Zodiac Constitution, which was written by Charles Moseley Bay in the 40s. And that constitution is not a state constitution, it is a culture constitution. When you read it, you begin to understand the culture, okay? And then the United Nations Declaration on the Rights of Indigenous Peoples, United Nations Convention on the Rights of the Child, United Nations Convention on the Prevention and Punishment of Genocide, Universal Declaration of Human Rights, Commercial Law of Nations and the Law of International Trade, 1972. Legal Maxims in Law and Equity, 1880. The Circle 7 Holy Quran, which was a seminal document that was prepared by the Prophet Noble Jew Ali in 1926, that is still in use today. The Mysteries of the Silent Brotherhood of the East, 1908. The Rudder and the Sextant, 1947. That might be a wrong date, but the Rudder and the Sextant. Now, we've used the Rudder and the Sextant for determining the titles of our offices, because it lays out the various titles and what they represent and mean in a Moorish government. And then the Kabbalion. The Kabbalion is a book that was written by the three initiates in 1912, and it lays out the 7 Hermetic principles, which you can find displayed and reflected within our Law of Restoration. Article 5, under General Provisions, the section that under the Dalil Aziz uses those principles to assess, evaluate, and adjudge whether or not a person is complying with or has the capacity to comply with governmental principles, the principles of the state. And then another document called Your True History, which has to do with our historical culture and so forth, the science within Moorish science, and then one on biblical law, Sundry Free Moors. The Sundry Free Moors, for those of you that don't know, were a group of there were 4 couples in 1790 that petitioned the legislature of South Carolina for not for their freedom necessarily, but for their rights to be treated as Moorish nationals, Moorish subjects, not as ex-slaves, not as Negroes, not under the Negro codes or the black codes. And they won that petition because they claimed a national standing with Morocco, for which they say they had fought. You see? So they claimed their freedom as Moors in 1790. And that freedom was garnered to them not because they said, oh, we're Moors. It's because they had an allegiance to a Moorish state for which they had provided armed service. Okay? Treaty of Peace between the United States and Morocco, 1836. The Treaty of Tunis. Treaty of Peace and Amity with Algiers, 1816. The Treaty of Peace with Algiers, 1815. The Treaty of Peace and Amity with Tripoli, 1805. The Treaty of Tunis, 1796. The Treaty of Peace and Amity with Tripoli, 1796. The Treaty of Peace and Amity with Algiers, 1795. The Treaty of Peace and Friendship between the United States and the Sultan of Morocco, 1786. The George Washington letter to Sidi Muhammad Ibn Abdullah, Sultan of Morocco, 1789. The world's oldest Homo sapiens, that's a document I found that said, let's put that in there. 2017, that's when the document was published. That document, by the way, showed the oldest modern humans in Morocco, 350,000 years ago. Citizenship of the United States, expatriation, 1906, is a document that we refer to that gives us a great deal of knowledge about our standing in relationship to the United States. Let's go back to that real quick. In 1906, this document, there was a phrase in there which says, any national or any citizen that cannot prove foreign citizenship is considered an ipso jure Moorish subject. Now, Moors often read that and say, okay, they know that we're Moors, so that means that I'm a Moor. Okay, great. But what they don't realize, when it says ipso jure, what law it says by fact of law. What law are they talking about? the law of the United States. So by the law of the United States, that party is an ipso jure Moorish subject within the United States. So it means you're still under the United States jurisdiction. You're still a subject of the United States, but an ipso jure Moorish subject. So they know the status, but they still claim the jurisdiction. Without a state, we weren't able to claim the jurisdiction. But now, with the state in place and firmly established in international law, we can claim the jurisdiction. That's what we're doing. General Treaty of Peace between Great Britain and Morocco, 1856. The Treaty of Ghent, 1814. The Jay Treaty, 1794. The treaty with the Delaware. Now, the Delaware is actually it's a derogatory term because it was taken from Delaware's Indians. I know this because I have a great grandmother my mother used to say was a Delaware. But the Delaware were actually the Lenape. And there was a treaty in 1778, a Treaty of Amity, Treaty of Peace, between the Delaware and the United States of America. Why did that treaty come into place? Because the United States of America needed a place to retreat to. They needed a jurisdiction that would provide them refuge from the onslaught of the British. And they also increased their army because the Delaware also fought on their side. 34, African origins of international law, myth or reality. Now that's a master's paper by a student. I forget the name, the university, but it's a very good treatise on the African origins of international law. When you look at all the treaties and all the declarations and all of the law and jurisprudence that came into play in ancient times, the large bulk of it had to do with African nations and empires. And when we talk about African nations and empires, we're not talking about just what we call the continental Africa west of the Suez Canal. We're talking about Africa that included Arabia all the way up into the Phoenician region where the Canaanites, Moabites, and so forth, all up to what we know today as Turkey, including Syria and Jordan and so forth. All of that was considered Africa. Okay, but it wasn't Africa because they weren't using that term then. Okay, now another treaty, Tel El Amarna Tablets, 1350. That was a treaty that took place. There was a couple of treaties that took place between ancient Kemet, Egypt, and some of the outlying territories. The next one, the Kadesh Treaty, was another of those treaties. The peace treaty between Ramses II and Hattusili of the Hittites in 1400 BC. These were treaties. This is part of our tome. This is ancient jurisprudence. Intro to the Code of Hammurabi, and then the Code of Hammurabi itself, 1780 BC. The Code of Hammurabi was in place so that Hammurabi, who was a bey, Hammurabi, was to oversee and rule over the Hebrews that had come into Babylon. Teachings of Ptah-hotep is another ancient writing. The Teachings of Ptah-hotep is the oldest entire book. It is a complete book from cover to cover. It's not long, it's maybe 40, 50 pages, but 40 pages, 30 pages. But it's the oldest complete books. Now, there are older writings, but none is a complete book, okay? The Teachings of Ptah-hotep. Ptah-hotep was a vizier, not a major, but a minor vizier in one of the temple cities of ancient Kemet. And he wrote this book for his son so that he could pass on his teachings to his son. And when you read it, the clarity of it is so striking we think that the farther back you go, the more difficult it will be to understand. Well, it's just the opposite. The farther back you go, the clearer and the more succinct and the more direct the language always is. The virtues of Ma'at, these are principles that go back at least 6,000 years before, or BME, so forth. Now, the Emerald Tablets of Thoth, the Atlantean, 36,000 BME. Okay? Now, these are all the documents that are part of our tome.
What does BME stand for?
Before the modern era.
Okay.
Yeah. And the modern era is considered to have begun in 3200 BC when they say that the Pharaoh Menes unified the upper Kemet and lower Kemet. Okay, so this gives you an idea. Now, what does this have to do with our Constitution? Well, our Constitution's on the top. Why is our Constitution on the top? Because it's our foundation. All of this represents the foundation that we're standing on. These are the principles that gird us up and give us strength. I like that word, gird us up, make us strong, put hair on the chest. Okay, now here's another one I wanted to share with you. Yeah, it's okay. There are other territories that are in process of doing what we have done. And those territories are right now in northwestern Mexico. And these territories are showing forth, some of them, everything is pending. There's one other that has everything complete except their inauguration. There's others that have their seal, flag, and constitution. There are others that are just in conversation and discussion and developing their seal and flag and working on their constitution. So there's various stages. There's about 12 altogether. So all of this is unfolding. Why is this unfolding? Because a constitution was written, a Moorish constitution of a Moorish provincial state government within the existing and pre-existing sovereignty of the Moroccan Empire. And so all of this is the Moroccan Empire. So what's happening is, as this starts to fill in, the Moroccan Empire becomes more complete. And the Moroccan Empire then can begin to establish its relationship state by state with each other to form a caucus that can then have voice in the international community through the United Nations. So that's the movement of things. And that's why we're doing this. There's no accident to anything. I'm not going to belabor this too long, but that's where we're at. Now, just to close out, if you're working on a constitution, don't be afraid. If you make a mistake, you can always change it. If you get the words wrong, you can always change it. You have an amendment protocol, make sure that you're following the protocol properly. The preamble, make sure that it's strong, that it's effective, that it expresses everything that you want the state to represent and to promote and to accomplish. Okay? Your dominions, be specific, be clear. Don't be clouded with it. Be very specific. Not so much so that it becomes confusing, but be very specific. Remember, these dominions, once your state is established, these dominions become uti possidetis juris, international borders, not just union state borders. They become international borders by international law. And your rights come from the Creator. 3 branches of government. Make sure that there are term limits. Make sure there's election protocols. Make sure there's oath of office. Make sure that there are constraints. Make sure there's checks and balances. You'll be in good shape. National trust. That's something we'll talk about later. And then the general provisions. What doesn't fit into these, you're going to go here and put in general provisions. And you're going to be as specific as you want to be. And then your supremacy clause and your delegation of authority. And then your amendment protocol. That's what you want. That's what you are going to use to build your constitution, to build your state, to bolster up your people and give your people the foundation that they need in order to thrive, to be protected, and to receive the benefit of the state. And there are benefits coming, because every Moorish state within Moroccan Empire has the right to carry out the edicts laid out in the Act of Algeciras, which was ratified by the United States government and signed by Theodore Roosevelt. And it was stated by Theodore Roosevelt that the United States acquiesced to all of the provisions in that treaty, which means that they acquiesced their jurisdiction to the jurisdiction of the Moorish states represented and spoken of in that treaty, which is our treaty, Act of Algeciras.
Oh, Algeciras.
Yes. So with that, I'm going to close. I want you to work on your Constitution, read your Constitution, study your Constitution. Remember, that is your governing instrument, and it will serve you, and you must serve it and make it a living instrument, an instrument that comes alive in your hands, in your mind, and in your heart. Peace and love to you.